Do you want to talk about the MRAPs?
Excuse me, can you tell us what an MRAP is?
An MRAP is a mine-resistant, ambush-protected vehicle. It's basically a tank ordered on behalf of the AISD.
They bought a tank for the school district.
It's not a tank, tanks. 3 of them at $1 million a pop.
So you're out of money? Is that still your official position?
Listen, if you think you can come in here and play gotcha in front of the whole town, you got another thing coming.
It's not just the town. I'm also live streaming this to my 5.2 million followers.
All right, someone get the cops in here. This is your last chance. Your team will vacate this hall immediately, or you will be arrested and you will all be fired. Officers, take these people to jail.
Oh, here we go. Anyone wants to leave, now's the time.
No way. Let's do it for Cap.
For Cap, to the end.
Captain Strand, I'm Sergeant Lynn. Do what you have to do, Sergeant. With your permission, we'd like to stand in solidarity with you on behalf of Captain Vega.
Buddy, as many of you guys know, I'm a law enforcement trainer and instructor. I train and instruct law enforcement and military all across the country on various law enforcement disciplines to include constitutional law, case law, patrol tactics, investigations, etc. And so, unfortunately, or fortunately, depending how you look at it, it seems like there's been a lot of good, clips from TV series and stuff when it comes to, things that we see in law enforcement. So I really don't know what this is off of, but I thought it was a really good clip to kind of do some, do a breakdown video. So it seems here that a fire captain is going to the city council to redress of grievances, which we're going to break down and look at. It looks like the police sergeant there, instead of making the arrest as he was asked to do, decided to stay in solidarity. And here's the real troubling thing about this. I can only speak for my training experience and what I've seen, but unfortunately, I feel like there are many police departments, especially smaller police departments across the country, where if the city council said, hey, we don't like what this person's saying, arrest them, I feel like they might do it. And the only reason I say that is because we're going to talk about a case here, but I feel like they might do it. I feel like a police officer may do it. And this is a question I get from law enforcement, especially younger guys. I get this question: what happens if my sergeant tells me to make an arrest that I'm not comfortable with? Or what happens if my police chief or my city council or the city manager, what happens if somebody of authority over me tells me to do something and I'm uncomfortable with it? What should I do? Well, I think and I'm not trying to be mean here, but common sense tells you if you're uncomfortable with it, then you probably shouldn't do something you're uncomfortable with. And you might be uncomfortable with for a couple of reasons. One reason, maybe you just are very ignorant of the law yourself. You don't know the law. Or number two, because they're asking you to do something illegal. There's always that possibility. So let's put the First Amendment up on the screen for you guys here. The First Amendment of the Constitution of the United States of America. Congress shall make no law respecting the establishment of religion or prohibiting the free speech thereof, or abridging the freedom of speech, or of the press, or of the right of the people peaceably to assemble and to petition the government for redress of grievances. Right there, it's in black and white. That's the First Amendment of the Constitution of the United States of America. Very important there. You do have the right to petition your government for redress of grievances, but don't let that stand in the way of a good narrative, right? Now let's talk about one of my more favorite Supreme Court case precedences as it relates to freedom of speech. I really like this one. It's the burning of the American flag burning. Supreme Court case precedents, Texas v. Johnson, 1989. Now, the reason why I like this one is because the Supreme Court did something very unique and something very, in my opinion, a very strong stance on the First Amendment. Okay, let's go back to Texas, right? Texas Penal Code. There's a state statute that says that you cannot desecrate a flag, essentially. A monument, place of worship, burial, or state or national flag. And in this case, the United States Supreme Court has held that flag burning constitutes symbolic speech that is protected by the First Amendment. The Supreme Court further held that freedom of speech protects actions that society may find very offensive, but society's outrage alone is not justification for freedom of speech. So here in this video, or in general, you know, as if you're a young police officer watching this, or somebody interested in knowing, city council's outrage of a message, especially if it's just playing "I gotcha" with funding, is not justification for the suppression of that speech. That's the Supreme Court. It's not. So, you know, redressing your city government, saying, hey, why did you do X, Y, and Z? I don't like how you spent this money. May be outrageous. Call it what it is. Outrageous that you would hold us accountable. But alone is not justification for freedom of against suppressing that free speech. So let's look at this in the perspective of an officer. You know what? He's going to make that arrest. He's going to make that arrest. All right here. The courts decide what is reasonable. This is something, again, I teach in my course. And so I think this is important. The First Circuit Court affirmed that Police Sergeant Bolter did not have the authority to arrest a journalist for filming a Pembroke Town Hall meeting and public officials talking in the hallway following the same meeting. Sergeant Bolter was following instructions from the commissioners of Pembroke Historic District Commission. Sergeant Bolter lost his qualified immunity. For all those people out there saying that cops don't lose their immunity, he lost his qualified immunity. The First Circuit held that a reasonable officer would not find the peaceful activities of a journalist amounting to engaging in disorderly conduct or disturbing a public assembly. The First Circuit further affirmed that a police officer is not a law unto himself. He cannot give an order that has no colorable legal basis and then arrest a person who defies it. Okay. Isambusi versus Bolter, First Circuit, 1999. So again, you know, as a police officer, if you're going to make that arrest, I'm not going to tell you what to do, but just realize there is clear First Circuit Court, and there's many other courts, but I like this one just because it is a journalist filming a town hall. There's precedent. Okay, somebody is utilizing their freedom of speech, and you're going to arrest them at a town hall. Okay, you can lose qualified immunity. It's happened. It's there. And again, this officer's trying to state, well, my commissioners told me to. Well, your commissioners can tell you to give them $1 million, but at the end of the day, you have to uphold the consequences, and you're going to be held to the consequences of your actions. Your commissioners didn't put handcuffs on the guy, Sergeant Bolter. You're a sergeant, and you put handcuffs on him, and that is why you lost qualified immunity. So there you have it. Freedom of speech is an important right. It's an important right that we have. It's something that is worth protecting, and as law enforcement, we have, taken an oath to protect the Constitution of the United States of America. So understand your oath, understand the case law precedents, and do better. Well, I hope this was helpful for you guys. As always, long live the Republic.